Good afternoon, whoever is left out. I don't know whether the lunch is calling or side discussions are more sort of interesting than bioprospecting. Now, first of all, two of my very eminent speakers had to uh, send me a regret that they would not be able to come. So you see only two speakers. So I voluntarily have decided that there is no role for a moderator. So I cannot moderate only my very distinguished speaker. So while coming, I tried to look into at least one of the speakers, what he was looking at, and converted it into, in the sense he didn't send anything, I had to do it myself. And with due respect, perhaps he couldn't have done that. So I will give an overview and presentation as to how things evolved. Before going into that, and as my friend sets up the presentation, which I've sent while coming, what is traditional knowledge? What do we understand by traditional knowledge? Why is there a need for protection of traditional knowledge? What do we understand by bioprospecting, and how things are evolving, things have evolved and things are evolving in the international scenario and in the national scenario? What are the concerns? What are the legal issues? What are the business issues or industry issues? We'll come to that. And while I present the overall perspective, I will leave it to the able hands of my very senior colleague and good friend, Dr. Malathi. That's her specialization, and bring in the Indian perspective of the law, how it progressed, and what happened, what are the latest decisions by the honorable courts, and then leave it to you for discussion. As you can see, less number of people on this side, more number of people on that side. We will entertain more questions. No questions are silly. All questions are important, and we will make the best possible out of those questions and try to make it as non-technical as possible, because this subject is technical. We all in India, we know very well, and whenever you are ready, you give me a signal. All in India, we know very well that India is very rich in traditional knowledge. Whether we use it for bioethnic medicine in the forms of Unani, Ayurveda, or traditional known medicines of other sorts, or traditional culture. In today's discussion, we'll focus only on the bioethnic medicine part of it. Now, how much of it is coming from biological materials or biological plant materials? How much of it is not? What is already there as traditional knowledge? Maybe in an unwritten form, maybe in a written form when you talk of Ayurveda. If it is in written form, how much of it is in Sanskrit and is not known to people? How much of it is in some local language not known to people? Now, in that scenario, where the traditional knowledge is out in the open, known to you and known to me, because our nanis and dadis have used those formulae, and maybe they're already known from the perspective of it is written in Sanskrit or in any other language, that somehow comes to in the hands of someone else who looks at it and says, okay, maybe we can stream out, use this material and extract something from there which can be modified further, and then if it qualifies the test of patenting, we patent that. So the resource is used, and then something new is made. And we call it, in very generic form, we call it bioprospecting. It is using that and then coming out into the new. Now the point is, traditional knowledge, if we now want to protect it, How do we protect it? Immediately people would say intellectual property rights and protection of intellectual property rights. But then conceptually, if you see, intellectual property rights is an exclusive right. You would say, no, this is what we would not allow you to copy. But here, it is wide in the open, wide open, the knowledge is there, and the knowledge has been used for quite some time. Now suddenly if you come and say that no, this is not going to be given any further, how do you work? So the model of protecting intellectual property rights in the traditional form and protecting traditional knowledge, it's difficult. It's not that easy. That is why there are two arguments. Those who are using those for bioprospecting and then going into the traditional form of patenting, their point is that, well, we have come with, it is already known. We have taken something which is already known and I've created something new. If that concept comes in, then based on that concept, we say, well, what would those communities whose traditional bioethnic material is being used, what are you doing to them? Why, if you are commercializing on that, why are you not sharing certain profit from your commercialization? And that is where the concept of access and benefit sharing comes in. So access to these community held traditional knowledge and in a structured manner access, how do you give access? And then that access when you give and there is further development, what would be the benefit sharing from there? So there comes, that's where I bring the topic to you all, traditional knowledge, bioprospecting traditional knowledge, patenting, access and benefit sharing. So with that, I will get into a brief presentation and then hand over to Dr. Malathi. At any point, if you have any question, I would request you to write it down, not to forget it. We would love to answer questions. Quite often people say that there was nothing, absolutely no protection at all. But that's not quite right. There was, historically if we see, we'll see there was some sort of protection of some way, but exactly what it protected differed. If we look into a bit of history, we'll see that the Indian Forest Act 1927, it tried to come in and regulate biodiversity materials. Now, I mean, I'm not going into the details because this is just to give you a perspective. Then after independence, if you see, we'll see in 1966, there was again the Seeds Act, which aimed in quality control, basically aimed at quality control and controlled seed varieties, maintained its quality, and that was basically their orientation. Much later again, if you see, the Wildlife Protection Act 1972, which was amended from time to time in 1993, it addressed the plant genetic matter and their derivatives. Now, when this was the scenario, I bring you back to the international arena and what was going out there at that time. We'll see that many of you might have seen the newspapers that time. Some of you had read it later on, much later on, that there was quite a bit of discussion and debate on how we protect traditional knowledge, whether there is a need to protect traditional knowledge. It all started around 1991 or so, and there with the UNEP summit of the Earth Summit at, if I'm not wrong, the Rio de Janeiro, it was the first initiation of the Convention of Biological Diversity. That's, that's how it started getting conceptualized in international scenario. Well, that was going on in three international organizations, three multilateral organizations. One, as I said, UNEP, one, WIPO, both of them specialized agencies of the UN. WIPO is the specialized agency for intellectual property rights, and the multilateral organization, WTO, the World Trade Organization. And if you look at how the developments have come in 1995 we see TRIPS, or the trade related, the agreement on trade related aspects of intellectual property, mandated legal protection, but did not mandate patents. As far as protection of plant varieties, they kept it open, possibility of sui generis legislation, that is any other innovative legislation that the member country would like to bring into. 2001 was the first time that WIPO took it up, and WIPO's Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, picked it up and carried on, and the discussion is still going on. I think December we will see the 32nd session, or 32nd or 33rd, most likely 32nd session, which is coming up. If you pick up the CBD, you see 2002, see the dates. So things have been progressing, but for at the multilateral arena, even in national arena, it's very difficult to come to consensus on many issues, and that you know better than anyone else. In an international scenario, it is even more difficult. 2002, we see the Bonn guidelines on access to genetic resources and fair and equitable sharing of benefits. This came up, this was initiated. And then 2003, we see Cartagena Protocol on Biosafety as to handling and transporting of living modified organisms came into effect. Now, at the same time, we also saw the ITG RFA also recognizing the indigenous farmers' right. This is the scenario. There's something written in italics. I don't know whether you can read it. India, traditionally, if you see at the multilateral level, had always been against, as a government, as a country, had been against the protection through patents, and it is more traditional knowledge is free, and that should not be getting into the realm of protection in the conventional IPR form. That was the position in the negotiations also. I had the opportunity to be there in Geneva. That's why I was very active in the advocacy as well as the research and work in this aspect at that time. India's position gradually changed. When India's position changed it, okay, we will protect so that we make sure that the protection helps us, but then we will regulate the access and we'll make sure the benefit sharing happens. And the benefit sharing happens in a way that the farmers and their rights are taken care of. So then we see the development in the national sphere. With this, I will gradually move out. The national sphere, we see the statutory development. We see new statutes. The Protection of Plant Variety and Farmers' Right, Farmers' Right Act 2001 came in. This is typically to make sure that we comply with the TRIPS on one side. It is a sui generis protection, and there we take care of the farmers. When the farmers' rights versus the breeders' rights, it is balanced. That was the intention. We see because of this gradually the National Register of Plant Variety, all the administrative steps, all the executive steps follow through. National Register for Plant Varieties came in, the National Bureau of Plant Genetic Resources came in, the Gene Bank, the National Gene Bank came in, the National Gene Fund was introduced. So there were varieties of administrative action. At the same time, work was going on in the next year, 2002, we see the Biodiversity Act, or the Biological Diversity Act as we say. The act was established, the NBA, or the National Biodiversity Authority, was established in 2003. Then with the drafting of the rules, the notification of the rules in 2004, it became effective, and then it was a three-pronged sort of statutory structure of administration. We see the SBBs, we see SBB, we see the BMC, SBB, the state biodiversity boards, and the NBA in itself distributed the work. At the same time, they make sure that there are certain changes in the patent law and in the Patent Amendment Act of 2002 changed and mandated disclosure of the geographical origin of biological material used when patents are filed in those patents where biological material are used. And they changed on the side of administrative side, they very elaborate procedure for patent opposition was introduced, and obviously where the disclosure, where the biological material needed to be disclosed, the possibility of depositing with the International Depository Authority was introduced through the administrative changes, and obviously later on we see India becomes an International Depository Authority. And at the same time we see that when I introduced this subject, we said that traditional knowledge was known without being, not in a written form quite a bit. Sometimes it was known in languages which were not known to the others. The patent examiners, so that international jurisdiction, other jurisdictions, patent examiners can access the traditional knowledge which is there, the traditional knowledge digital library was introduced. And the interesting part of it is that it facilitated access because the languages, it is translated, the knowledge information translated in the lab, quite a number of other languages of the world, apart from English, Japanese, French, German, and Spanish. So obviously this helps when the examiners are looking at assessing prior art when they are examining, and also the other distinguished work that they have been doing is trying to look into balancing of the classification. They have already established the knowledge resource, traditional knowledge resource classification, and now they're looking at possibilities of international patent classifications, and how much with that. With that, I will request Dr. Malathi to take it forward. Thank you.
Well, I'd like to thank Inva for giving me this opportunity, and also Santanu for inviting me to be a speaker. So my background, I've been 25 years as a scientist, and now I'm in the field of patents. I'm a patent agent, qualified patent agent, and I do a lot of work in PVP, plant variety protection, patents, and the biodiversity, which is actually a good confluence and interplay with all these key things. And I'm sure a lot of you people have heard about the latest things that's happening in the Biodiversity Act, and I think Santanu has done a very good job of introducing the subjects, and that they have protection in so many areas. What I would like to do today is to approach only on the Biodiversity Act, and that's a very recent act, as you said. It was passed in 2002 and got implemented in 2004. Now, India is a very rich country as far as biodiversity is concerned. We have more than 20 hotspots all over the world, and in India alone we have 3 main ones, I would say even 4 hotspots. What do I mean by hotspots? Hotspots are regions where it is rich in biodiversity. There's a natural biodiversity in that region. So if you take Western Ghats, all the way from Maharashtra right up to Sri Lanka, we call that as the Western Ghats. And it has a lot of, it is the Western Ghats, and you have a lot of natural biodiversity there, and it could be plants, animals, microorganisms, fungus, insects, and so on. So one is the Western Ghats. We have the Himalayas. So the Himalayas, the whole range of Himalayas up to the northeast. We also have the Indo-Burma region. So like in the Indo-Burma region, that's the place where rice actually originated. If you have tea, tea was in China. So there are certain things. Mango is again the center of origin is India. And the fourth hotspot is called as the Sunda lands, which is the Andaman Nicobar area, which is the fourth hotspot. So we have the Western Ghats, we have the Himalayas, we have the Indo-Burma region, and then we have the Sunda lands. Why? If we are so rich in biodiversity, has India, the government of India, really done anything to protect its biodiversity? And as you know that we are in a developing mode, we have so many things, our forests are cut down, we need more housing, we need more land for agriculture, and so what are we doing? And that to keep sustainable use and conservation of biodiversity. With this aim in mind, the Biodiversity Act was enacted, and if anybody uses this biodiversity to do commercial utilization, then they have to pay back to this thing. Now, so this is the reason why we have the Biodiversity Act. And if you look at the Biodiversity Act, this act actually said for conservation and sustainable use of biodiversity. Why? Because let's say India is very rich in rice. We have the basmati in the northern part of India, in the Himalayas. If you grow basmati in, say, Texas in the United States, can they call it basmati? Do we need to protect our basmati so that anybody trying to sell this, we do get something back to this country? So this is one example of basmati that I'm talking of. It could be like Darjeeling tea as well. Of course, you have GI. I'm not talking of geographical indications at this point of time. But are we, if suppose we had, let's say, 10,000 different varieties of rice. Earlier on, even 50 years back, every home, every region, even if you went to Dehradun, every farmer would like to have his own variety. But today, because of monoculture, some of the varieties doing better than the others, we've really shifted towards monoculture, and you don't have that many varieties. But a lot of our varieties are now in the, here. Yeah. Right. Where is the other way? So this is the reason why I will be talking about how do we conserve. So suppose we had 10,000 varieties of rice. I agree, many of them are in EV, in Philippines. How much do we have? Have we conserved it? Tomorrow there may be some very important traits like insect resistance, fungal resistance in these wild varieties. Some of them may be having very nutritious properties. Have we conserved those? Is the real issue that we have. So today, actually, I will be trying to cover some of these things. I know it's a lot of things, but I'll try to cut down and really only be with the Biodiversity Act here that I will be talking about. In the Biodiversity Act, we do have a lot of issues, and one of the issues is who can access Indian bioresources. And when I say Indian bioresources, it can be plants, animals, insects, fungus, bacteria, and so on. Who can access these bioresources? Under Section 3, the Section 3 really separated Indian and foreign. Indian company, foreign company. Indian national, foreign national. So anybody who is an NRI, anybody who is a foreigner cannot access Indian material, and they need to go to the NBA, that is the National Biodiversity Authority, and get prior approval before they can access any bioresource material. So this is the issue. So today we know that you can have aloe in a shampoo, correct? You can have aloe in a soap. You can have neem in your in a soap. You can have clove oil in a toothpaste. So before they access that material, if you're an Indian company, what should you do? If you're a foreign company, what do you do? And therefore, who can access bioresources? For trading, yes, any trader can trade. That doesn't say that it is part of the Biodiversity Act. But who can access bioresource material? If you see section 3.2, 3.1, anyone who accesses bioresources for research. So first thing, anybody doing research on biodiversity material will have to go and be clear about the section 3, or for biosurvey and bioutilization, and third is commercial utilization. So if you're an Indian company or an Indian national, you don't have to get prior approval, you can use it and do it. But if you are a foreign national and if you're a foreign company, you have to get prior approval from NBA if you touch any bioresources for research, commercial utilization, biosurvey and bioutilization. So here is where we have issues, because according to this act, who is an Indian company? If you're registered in India and you're traded company, you're listed company, and even one foreigner buys a share of your company, that becomes a foreign company. So there is a little amount, but in the Companies Act, everything else, it is not so. You need 51% equity or partnership before that becomes a foreign company. So here, one share in your company or a director of your company is a foreigner, it is considered as a foreign company. So all those Indian companies which we thought are Indian companies under the Biodiversity Act cannot be considered as an Indian company. It will be considered as a foreign company, even if it has one share. So we have to be very, if you are a foreign company, you have to go for approval to the National Biodiversity Authority if you do any research on biodiversity material. And today I mean research, as you see, the more and more that we are using biomaterial. It could be in your shampoo, it could be in your cosmetics, it could be in your toothpaste, it could be in your hair oil, it could be your Maggi noodles. Everywhere you see there is so much of biodiversity that we use, right? And that is where we have to be careful about. If you are an Indian company, I said you are a foreign company, you need prior approval for access of any biodiversity material. There are some exemptions which I will come to that, but section 7 clearly says that if you are an Indian company, you don't need to get prior approval for access of biodiversity material. However, you have to intimate the State Biodiversity Authority and tell them that you are using this much material. Let's say somebody wants to make a neem soap. Most of the particles, most of the things in the soap are not biodegradable. But if I put neem oil or I put some neem extract into a soap, they have to inform the State Biodiversity Authority that I am using neem to make a soap, right? If it's an Indian company, if you're a foreign company, you can't touch neem. You have to get prior approval. So this is where you have, and the reason here, there can be criminal proceedings in this act if you do not follow this act and you do not comply with this act. So that is why you have to be very careful. Also, there are certain issues here about what is research, what is biosurvey, bioutilization, what is commercial utilization. All these definitions are also a problem because it can be defined differently. We do not have too many case laws, and that also leads to a lot of problem. If I just want to take up section 7 again, it only says that I have to inform and intimate the State Biodiversity Authority, not for research. So if there is Delhi University doing research, they don't have to tell. But if they're doing anything with commercial utilization, or they're doing anything on biosurvey, bioutilization, for commercial utilization, they have to just give prior intimation to the State Biodiversity Authority. One more thing is transfer of research results. So in biodiversity, when we use any material and we transfer research results. So let us say I talk about neem soap. Sometimes neem along with clove may work very well. So there are some results that I want to transfer. So if you transfer research results from Indian company to Indian institute or an Indian to Indian, no problem. The minute I transfer it to outside, you have a problem. So let us say Pepsi wanted to transfer some of the algae outside of India. They have to go to NBA or data with algae or data with any of the biotech material or bioresource material. Any transfer of research results prior approval of the NBA is required. If an Indian institute or an Indian company or an Indian person wants to transfer it to a foreign company or a foreign institute or a foreign national. So this is one very important. What was this? The topic was, where is this confluence or interplay between patents, which is an intellectual property, and the Biodiversity Act? That comes because of section 6 in the Act. And in section 6, there is no differentiation between an Indian company, a foreign company, an Indian national or a foreign national. Anybody using bioresources and they come out with a patent. Let us say they come out with a product which is very good for disease resistance, or you come out with a material which will be very good for diabetes. Let's say a Karela juice which is very good for diabetes, or a jackfruit powder which is very good for diabetes. In such a thing, if you come out with a patent, then anytime you write a patent on a bioresource material, a bioresource material could be cow from milk, paneer from milk. It could be any material, any bioresource material. If you write a patent on it and you want to get protection under patents, you have to get the prior approval of the NBA. And here, if it's a foreign company that use foreign material, no problem. But if it's an Indian company, an Indian institute using Indian material and writing a patent, here. So here in section 6, anybody doing any work on bioresources and writing out a patent will have problems. So let me say somebody wants to use bagasse or waste material and you want to convert it to ethanol, or you want to convert it to biogas. What happens if you use waste material and I want to make it into paper? Then they say, sorry, even if it's waste, if maybe under Swachh Bharat that you want to clean up and you don't want to burn, like what's happened in Punjab and Haryana just before Diwali, they burnt all the stubs, correct? This was, they were growing rice and now they had to grow wheat. They didn't have labor, it's a labor problem, it's expensive to take off the stubs which are in the ground, and they burnt it, right? And you had pollution. So the government of India or the Supreme Court might say, no, no, burning is not allowed, but that's a cheap alternative for the farmer. Let's say that one of them in Uttarakhand was very smart. He said, okay, I take all these stubs and I can make a paste of it, I make a thing and I make now paper. And very good idea. Another person said, I use all this waste material and I'll convert it into alcohol, which can be used as biodiesel, and the remaining of that thing can be used as a fertilizer. Immediately the State Biodiversity Board of Uttarakhand said, sorry, you are using a bioresource and you pay back. So tell me now, who is going to be coming and saying, okay, now come, let me do cleanup. So this is the way, because the way the act is written is a bioresource. So even if it is a waste material, it is still a bioresource. And so anybody using bioresource, let's say we have wood, correct? We have furniture. Where is furniture coming from? Wood. Is wood a bioresource? Yes. Paper, where does it come from? It comes from plant material. Where is your cotton shirt coming from? Where is a silk sari coming from? Remember, all these are bioresources. And the way the act is written, it's very difficult for NBA to say, I exempt this, I do not exempt that. So we have to keep thinking, and it's an act which has criminal proceedings if you do not comply with, and that is why it becomes a very tricky one as well. So this is for transfer of biological resources. You want to transfer outside, like I said, Pepsi did transfer a lot of algae outside of India, seaweed algae. You can get permission and you can do it. In the NBA, when it has important things like say sandalwood or red sanders, if you want to export, they are not saying don't export, but if you want to export wood, you want to export aloe vera, you want to export basmati, anything that you want to export, you need to pay a certain royalty back to the gene fund in NBA. So people have exported red sanders, and red sanders is a very important wood, and they have collected a lot of money like that. So anybody sending out eucalyptus, then the government of India will say, okay, there's a customs problem, I'm not talking about that, I'm talking that you have to pay back to the biodiversity if you export anything out of this country, if it is a bioresource. And so what happens? Today we are eating strawberry jam, we are having pineapple jam, mixed fruit jam. That's also bioresource, right? There's somebody, Kisan, they're using the bioresources. Sugar, they even had a problem, is sugar a bioresource? And in Madhya Pradesh, State Biodiversity Board sent out 700 notices to a lot of companies working in the area of bioresource. And one of it happens to be a coal mining. They said coal is a bioresource. Why? Because it is a fossil. So what if it went millions of years before under the ground and now it is considered to be a fossil? And therefore there are judgments on that and says anything which is a mineral, anything which is a coal cannot come under the definition of a bioresource, even though it is plant material which became a fossil, which became coal, which became oil, which became petroleum and so on. So that at least we have clarity. So each of the state biodiversity boards are sending out notices. Maharashtra has also sent out notices to all the Ayush companies. Karnataka has sent out notices to a lot of companies and said, you are using your bioresources and making commercial products of it, please pay back to the gene fund or to the state biodiversity board. So we have, where do we stop? Where do we go? So these were the issues that we have. We have issues on what is the definition. We have issues on when did we access. The Act came in 2004. Let's say for research I access pre-2004. Do I have to still come back? What does the NBA say? Are you using it today? Yes, if you're using it today, you have to pay back. And all this came up because of the access benefit sharing that we have and the COP21, and we decided that we would have this access and benefit sharing for bioresources. Another very important section is section 40 of the Act, and section 40 of the Act says certain bioresources will be exempted. So first India came up with about 190 species which were exempted. Today they have come up with about 385 species which are exempted. So rice, wheat, maize, soya bean, cotton are all exempted. But they are exempted for what? They are exempted for trading. So you have 385 species exempted for trading. So if you want to trade rice, you want to trade wheat flour, you want to trade soya bean oil, you want to trade any oil or flour or things, those are exempted. Or any of the things which are like all your vegetables that are trading is exempted. But let's say from Karela, I isolate a molecule or I isolate Karela extract and I want to show it as anti-diabetic, then that is not exempt. Castor oil in Maharashtra, people were using a lot of castor oil before Holi for burning and doing other things. They said castor oil as such, you drink it, no problem. Castor oil, you use it at home as a trading, no problem. But the minute you use castor oil to make soap, you use castor oil to make cosmetics, then you have to come to this Act and you have to pay back as a certain amount of royalty. And so about a year back, there was this guidelines on how to do this benefit sharing. One more issue that we have, as you talked about the International Treaty on Plant Genetic Resources for Food and Agriculture. This is an international treaty under the FAO where they said 64 species for food security like rice, wheat, oil, vegetables, fruits are required by humankind. Today wheat came from South America. Potato has come from South America. Today if you eat in your plate, 80% of that material or biomaterial has come from outside of India. And if in government of India starts putting up a percentage, then we may not have food security. Chile might say potato is ours. Each time you eat potato, please give back some amount back to me. Wheat, Mexico can say green revolution came because of Mexico. Then we might have to pay back. So FAO said 64 species are required for food security for mankind, and that should be freely accessible to all. You cannot say it is mine. It has become the world's heritage, and that is why there are these 64 species which will be governed by the Ministry of Agriculture. All others will be governed by the NBA, which comes under Ministry of Environment and Forests. And therefore, again we have issues here, because if you are a Section 3.2 company, NBA says you will not get exemption under the International Treaty on Plant Genetic Resources, but you have to come there. Now, one more thing that has happened is on conventional breeding in agriculture is exempt. PVP under the patents under the Section 6 is exempt. And so this is the way it works in the NBA. If you are a 3.2 company, you go to NBA for approval. If you are an Indian company, you go to the state biodiversity. If you are using it from small communities, you have to actually go to the biodiversity management committee and intimate them that you are using all these materials. As I said, consequences of non-compliance can be a serious issue. They can give you a fine of up to 10 lakhs or so, or the punishment can also extend up to 5 years of imprisonment, and that is why complying with this act is very important. These are the different types of benefit sharing that you can have. I'll just go quickly and just to tell that if you have anything which is more than a 1 crore to 3 crores, you have to pay 0.1% benefit sharing back to the gene fund. If it's an Indian company, you give it to the State Biodiversity Board. If you're a foreign company, you have to give it to NBA. Anything between 1 crore and 3 crores is 0.2%. Anything more than 3 crores is 0.5%. It could also be that it doesn't have to be always monetary. You can say I can start a school. You can say I want to build bridges, or you want to build roads. It can also be non-monetary, but at this point of time the NBA doesn't know how to do for non-monetary. So for everything that is monetary, so let me say if you have an aloe vera shampoo, in the whole shampoo there may be less than 1% may be aloe vera, but you still have to pay 0.1% of that shampoo price as royalty back to the gene fund. So this is something which most people are not doing, and most people are not aware about it, but it is there from November 2014 that you have to pay certain benefit sharing back to either NBA or this. I don't want to take more because this can go on, but if I have any questions on this, I will be very happy. There's only one thing here. The way the act was written, it looked like agriculture was out of the purview, because plant variety protection is out of the purview of NBA. And if you look at this section 17, they said conventional breeding in traditional practices of agriculture, horticulture, poultry, dairy farming, animal husbandry, beekeeping are all exempt. So beekeeping, honey is exempt. But today you try to sell honey, they are going after all those people and saying, no, no, your method of agriculture, method of beekeeping is out, but however the honey is not. Honey is a bioresource and you have to pay money to that. Value added product is not a problem at all, but what is a value added product? Dabur Chyawanprash is a value added product, but to make value added product you have to go and get the bioresource and do so, you have to pay for it. And this is in short that I want to talk about it, and if there are questions I'll be happy to answer that.
As I said, the topic is technical, but the questions need not be, and we'll make sure that the answers are palatable because, of course, there's better choice outside when we go for lunch, but still, I think it should meet the interest of the intellect.
Good afternoon, everyone. I'm a law student, final year law student for Campus Law Center. So the question is regarding to traditional knowledge and genetic resources. So when we're talking about the sui generis protection as being provided by BIPO guys and as well as the other international forums are talking about. So the other thing which I want to ask about is like the government of India or any ministries of that are believing for traditional knowledge reciprocity with the other tropical countries or other countries as a result, because there is a reason. As when we talk about traditional knowledge or genetic resources, either we deal with the implementations in the natural day lives or in the pharma industries. As in the state of Kerala, there are ants whose space is being used in the prostate cancer, and this knowledge is being shared with the Brazilian medical institute, so their prostate cancer could be like cured with that traditional knowledge. And even what's going on in the arts like music, even a folk dance of Rajasthan is a traditional knowledge for India. So this sharing is such sort of reciprocity is going on with the other nations, or still we are being just protecting it and not opening our wings with the other world as the inter-exchangeability of this traditional knowledge. So
Thank you very much. It's a very good question to, please allow me to rephrase the question. We were talking from the perspective of India being a material rich country, a resource country. But at the same time, India is also a user country. And his question, if I understand properly, is subsequent to the Nagoya Protocol, where how do you distinguish between the access by the other countries, we talked about foreign countries in India, benefit sharing, royalty percentage payment, what we are doing in compliance of Nagoya when we are utilizing the resources from, say, Peru or some other country. Am I right?
yeah, especially the tropical countries.
Access and utilization, where do you balance it? Dr. Malathi.
Yes, I mean, it's a one is also you talk about traditional knowledge. Right now, Government of India, we really don't know how to protect traditional knowledge, because whenever you want to protect, you have to bring it out. So let's look at our Ayurveda things. If you bring it out completely, then where is traditional knowledge? Traditional knowledge is something that comes down from family to family, from your ancestors. It's generally kept within a few families, and that is where you have traditional knowledge. It's more like sometimes it could be trade secret within the traditional knowledge. So it's in Government of India hasn't enacted anything to see how you can protect traditional knowledge. Only thing that they have done is you cannot get a patent on a traditional knowledge. So let us say that there is a certain molecule or something which can protect against prostate cancer, and that was a traditional knowledge, you cannot protect it under the Patents Act. That is one that we have. As far as each country who have signed, so at least 50 countries had to sign the Nagoya Protocol. They have signed it, and now Europe also, most countries who are there will have, except United States. All others are implementing the Nagoya Protocol for access and benefit sharing. And so if you want to get something from Brazil or Peru or somewhere, you have to comply with the act there. You cannot now take any material. That was because there was a lot of biopiracy. You've heard about the turmeric case, how somebody outside India in United States tried to patent the turmeric as wound healing for topical as well as for internal use. You had heard about basmati, texmati. So to stop this type of piracy, that the Government of India has come up with this National Biodiversity or the Biodiversity Act. So each country, Brazil has its own Biodiversity Act, Peru has its own thing. So you'll have to comply with the act if you want to bring anything into this country. Or the same way from here to the other countries.
So may I address it very quickly because I see all the guardians of time are standing there. So may I say that those three aspects that you have mentioned are not separate. There is a social aspect to the financial aspect to the social aspect, and you cannot differentiate. And if you look at how the legislation has evolved, it has evolved from the community social aspect. Okay, this is our community resource. It is important that we protect it. Now that you are using it and making money out of it, please share some percentage. So all are interplaying. So the government is looking into it. From the perspective of there is your question as to access utilization and outside, we definitely will need to comply, and we comply to the sovereign laws of sovereign countries. But there is a demand and there is international discussion also that whether we ourselves need to do something to make sure that we are complying to other resource-rich countries outside. That is a discussion which is going on, and we'll see how it progresses. I think your question was very much answered when she made the presentation, so I'm not diving back to your question. One very quick question, if anyone is there, and then yes, sir.
More than a question, it's a reference to what Mrs. Malathi said about the haldi, turmeric. I was surprised to note that in California, they were selling a coffee type thing called turmeric latte for $10 very recently. I came across. So in fact, I was alarmed. I said, turmeric latte, what is this? It's only haldi milk, which has been going on in our country for ages. So just a food for thought.
Well, there are so many like
there are many like that. I mean, we can, but government of India will actually have to do something. Turmeric is that if you do enough homework to then, go and tell you cannot use this because it's traditional knowledge.
very quickly, because this is very interesting what you said. We usually used to earlier wake up a bit late. And that was the case for turmeric also. And we had to get it nullified in easy terms, if I say so. And to do that, we had to establish that the antiseptic property of turmeric, or kurkuma as it's called scientifically, was known. And it was very difficult to establish that it was published somewhere. Finally, it was found out the ruler Tipu Sultan was a Caesarean baby, and the Unani, the doctor, physician, whoever, had used, yes, I was not getting it. So, yeah, exactly. So had used turmeric as an antiseptic, and that was established because that was on a tablet in a mosque. And that, the reproduction, that's a photograph of that, was presented to establish. And that is where, that's one example, where coming into the TKDL or everything, recording of that is going on. And if you talk of Basmati, they tried Basmati, Jasmati, Kesmati, at the end, Texmati. With that, I will close it.
Thank you so much, panelists, for the deep insight on this very interesting and important topic.